Hello everyone. So in today's class we will first discuss about the meaning of company, because in the last class we started with knowing the structure of our syllabus, what is included in our syllabus, what is not included in our syllabus, and the very first content that we are going to begin with is the part of corporate law, right? So corporate law has a very good coverage, and in that you have three topics prima facie, which is Companies Act, IBC, and corporate governance. So when we talk about Companies Act, we don't have to read the entire act. As I told you, we have to read some selected portion. So before we begin with Companies Act, which also includes some content which is repeated, that is, you have read that at the interlevel also, and again you will be reading it, but I'll teach you. Right, we will read about it. But before that, we need to know the basics of company. Ma'am, are these basics of company incorporated in our syllabus? The answer is a big yes. You have certain basics that you have to reread. I mean, you have read it before, even before, right? But still, you are supposed to read it, and even questions are asked in examination from these very basics. But then when questions are asked in examination from this basic, the basic is huge, you all know that, right? You have a lot of content that you can say, okay, I know this about companies, but my dear, you don't have to learn everything about company. You will only be learning the part that I tell you for your exam perspective. Okay, so first we will discuss what company is all about, what are the features of the company, and thereafter we will begin with Companies Act, wherein we'll come to section number 1 first, which talks about the short title, applicability, and commencement, and thereafter we will be discussing section number 2, which is all about definition. So we have a lot of terminology that we need to discuss in the Companies Act. Now, when we look at the characteristics of company, you'll find these characteristics everywhere. But then, when we talk about our CMA final law examination, and when I'm saying this, of course, I am talking about your 2022 syllabus. Just a second. So, my dear, this is what you have to remember for your examination perspective. Ma'am, what is it? See, company. The first thing is, what do you mean by company? Company, if we go by the literal meaning, it means having bread together, right? So when someone is doing business together, that is a company. But when we actually look at the meaning of the company, it is some people who are coming together to do a business, and the form of business organization that they're choosing is company. So if you look at the definition of company from Companies Act perspective, any such form of business organization has to be registered with an authority, and only then it will be called as a company. And if it is registered with that authority, that means you choose to do business in this particular form of business organization company, then you have to follow Companies Act 2013. My dear, you have ample of forms of business organization. The very first one, proprietorship. If you go for a proprietorship business, which is eventually found in, I would say, every corner of a lane, right? So if there are 10 shops, 9 would be proprietorship, I would say. But then what is proprietorship? In proprietorship, there is no distinction between the business and the person who runs it. So I own a proprietorship store. I have a shop through which I'm doing business, and that is a proprietorship business that I am doing. So in that proprietorship business, I need funds. So I went to a bank and I took loan of say 5 lakh rupees. I could not repay that loan. Now that loan, other debts, maybe I have taken a lot of goods from the creditors, I have taken a lot of goods from the creditors for resale, but I could not resell them. Now they have also become obsolete, they have expired, I have to make payment to them also, I've taken loan also. So I have so many debts to pay, but I don't have any assets in the company, because all the assets have expired, something has happened, right? So I don't have any assets in my business, what do? The bank will come after me, creditors will come after me. I can never plead that this is the business and business does not have assets. So, how do I repay you? No, they'll come after me. Because I am as good as the business. There is no distinction between business and me because it is a proprietorship entity. So I can be personally liable for their debts. Not only my business is liable, but I am also liable. So this is the biggest advantage a company has over other forms of business organization, apart from other advantages also. But then it gives you the feature of limited liability, it gives you the feature of perpetual succession, it gives you the feature of separate legal entity, right? We all know this. We are not that little kids that I have to take every example and I have to tell you, okay, fine, there is a case law, Salomon versus Salomon. I'll take half an hour to explain you that particular case law, and thereafter you will understand what this is all about. No, not needed. Neither from examination perspective nor from your mind perspective, because you already know these things and we have to move on. All life long we cannot be at ABCD, right? So this is ABCD of Companies Act, which you know. So a quick recall, my dear, and this is how you are going to recall, and this is how you are going to write in your examination if at all such question is asked. Company is defined under Section 2, Clause 20 of the Act, which I'll repeat again, but it means registered under this act or previous company law. As I told you about the history of Companies Act, we had Companies Act 1956. Even before that we had acts. 1913 was one of the important ones, but even before that we had acts. So these are all called as previous company law. So law relating to company which was previously there, it is previous company law. So if, let's say for example, Reliance Industries Limited, it is a very old company established under Companies Act 1956. So it was incorporated when there was Companies Act 1956 in picture. It was incorporated. Thereafter, that act was repealed and a new act came into picture. That means now these companies, do we need to re-register under Companies Act 2013? No. All the companies with old registration, with old incorporation are very well treated as companies under Companies Act 2013 also. Okay. So, what is company according to Companies Act 2013? It means all the companies which are, all the associations which are registered under Companies Act 2013 and also previous company law. Fine. Okay, ma'am. What is a company? Ma'am, if you are asking the definition of the company, this is the definition. If you are just asking the meaning, well, it is a group of voluntary association of some people who have come together for a common business objective, and they have chosen this particular form of business organization. So they have registered themselves under Companies Act 2013 or previous company law, and they'll be called as a company. Right. Okay. What are the features of the company? These features are somehow the advantages also, some of them, most of them. The very first one, independent corporate existence. Oh my God, what is this? This is the most amazing feature, as I told you. Now, the identity of a company. See, a company is an artificial person, just like we get a separate identity as and when we are born, right? But it takes years to build up that identity. A child is born, he gets a birth certificate, and now he's called as a separate person. Right, till the time he's in the womb, it is as good as the person itself. Right, the moment the child is born, he gets a separate identity. He gets a name. Likewise, when a company is born legally, who makes it is now different. Okay, so who is making it, who has made it, who is going to govern it, who is going to manage it, they're all different people and the company is different. So the company gets an absolutely independent identity which is different from its members. We have a beautiful case law of Salomon versus Salomon and Company, but mark my dear words, you don't have to read the entire case law at the final level. Of course, you remember the case law name, I'm sure, because you have come so far. So I'm sure you remember the case law name, and you should remember that. Okay, so they are different persons, and a company will get a separate corporate personality, which is going to be different from the members who have actually incorporated the company. So there are some promoters who have taken efforts to incorporate the company is different from the promoters. Now what is going to happen if a company is formed and company goes and takes a bank loan, and the company is unable to repay that bank loan? Well, the bank will come, and the bank can take money only from company. If company doesn't have bank money, it is all the bad debts of the bank. The bank cannot come to the members of the company and ask that you have formed this company, now you give me money. No, why will we give you money? We have formed the company, but it is separate and we are separate. Okay, we have formed the company, we have elected some directors to run the company, we are all running it in good faith. We are not responsible for the debts of the company. Here comes the second most beautiful feature, which is limited liability. Limited liability. Now, mark my words, when I say limited liability, the liability of company is always unlimited. But if a company is formed limited by shares or limited by guarantee, then the liability of members of the company is limited. Okay, I'm not writing this again. Although I had to make you write certain things, but I'm not writing this particular thing again, because so far I've only told you yesterday. In the last class, I made you write certain things, right? Now, here I'm not writing certain things because these are the features that you need to remember. And if at all they are asked in examination, you have to elaborate every heading in a sentence, one or two. That is it. Right. So now limited liability means what? The liability of the members is now going to be restricted. If I have said to the company that, okay, company, I am going to start you and I'm going to give you a funds of 50,000. So if I've promised the sum of 50,000, I am liable only for 50,000. If I've promised a sum of 20,000, I'm liable for only 20,000. Now, this money can be contributed by me in the form of shares also. We'll read about this slowly and gently, no rush, no hurry. Fine. So, no member of the company is bound to contribute anything more than what he has promised. Okay. So, if it is shares, whatever amount I've promised on shares, that I'm liable to contribute. If I have paid half the amount, I'm still liable for the remaining half. That is the unpaid amount on shares which is held by me. If I have given a guarantee that if the company is unable to handle its assets, then I'm going to contribute to the assets of the company, and I have guaranteed an amount of 50,000, I'm liable for only 50,000. I'm not liable for more than that. Okay. So I'm only liable for the amount which I've not paid on shares or which I have undertaken as a guarantee. There are two types of companies when the company's liability, when the company is registered as a limited company. So it could be limited by shares or it could be limited by guarantee. We'll read it. Then comes your perpetual succession. See, if it is a proprietorship firm, and it is run by Mr. X. Now, Mr. X was going on a highway and the car's speed was somewhere around 160, and boom, an accident took place and he died on the spot. There's nothing to be happy about this, but then what is going to happen of his business? Ma'am, he had a shop. The shop will obviously be taken by his legal heir, right? Maybe he has a son. So now the son is going to sit on that shop. So how the business ends in a proprietorship? Well, the business actually ended. The business or the proprietorship was in the name of Mr. X. Now Mr. X is no more, right? Mr. X is no more. So entire formality has to be done again. Now the proprietorship person will change. So that business is now over. Now there will be a new business, although that same shop will be taken by another proprietor. Right. The same happens in the case of partnership also. If there are three partners and one of the partner dies, immediately the partnership is dissolved. Now there will be fresh partnership. Of course, the other two partners can continue this business, but the partnership got dissolved. Now you'll have a fresh partnership. There will be two partners. Now you'll have a fresh partnership deed. Everything changes. But in case of company, it doesn't change. Even if all the members have died, the shares will be transmitted to their legal heirs, but the company will be intact. If ABC Private Limited is formed and all the members of ABC Private Limited die, still the company will go on and on and on. Right? So members may come, the members may go, but the company is not going to dissolve until you want it to dissolve. Fine. So the membership of a company may keep on changing, but it's not going to affect the continuity of the company. Fine. Clear? So the company goes on forever and ever and ever. Then comes your separate property as separate owner. When a company is a separate person in the eyes of law, it can hold property in its own name. There can be a building which belongs to ABC Limited, right? If I have formed a company, I started a business, I formed this particular company, right? That means I took the efforts to form this company. Now, this company is separate and I am separate. I cannot say that I will take the funds of this company. I'm buying a property from the funds of this company and I'm buying the property in my own name. No, 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 no. The company will have the property in its own name. The company is capable of owning a property. The company is capable of disposing a property. The company is also capable of enjoying a property in its own name. No member is going to intrude in this. Fine. So the company can also mortgage that particular property and take a bank loan, right? So that is the possibility. Then comes transferability of shares. What do you mean by transferability of shares? Now, you all know that when the members contribute to the capital of the company, they're being issued shares, right? If the entire capital of the company is of, say, 2000 crores, every member will have a share in the share capital of the company. The smallest unit or the least amount that can be collected from any member is just the smallest unit. Supposedly one share price is rupees 100, so below that the company will not accept. You can take either one share, you can take two shares, you can take three shares. Likewise, you can contribute to the company. So that is my share in the company. This my share in the company can be transferred also. In case of public company, it is freely transferable. In case of private company, there is restriction in transferability, but undoubtedly, in both the cases, the shares can be transferred. And the last feature that we are reading over here is common seal. Now, common seal is basically the stamp of the company. Earlier, it was mandatory that every company must have a common seal. Now, it is optional. So, after Companies Amendment Act 2015 came into picture, it became optional that now the companies may have a common seal. They may not have a common seal, right? One line which I want you to write. In case, please write everyone, in case a company doesn't have common seal, although we read about authentication also, but this is something that prima facie you all should know. See, company is a separate person. We have to sign on every document. If I enter into a contract with anyone, I will sign, the other person will sign. Now, company is an artificial person. Company cannot pick a pen and sign, right? They cannot do that. So, on behalf of company, somebody has to sign. Earlier, we had a stamp, and the power to fix a stamp was given to someone. He kept the stamp in his custody, and whenever it was that, fine, okay, this is a document which has to be signed on behalf of the company, there was a common seal affixed. But now, a company may not have a common seal. So, if the company doesn't have a common seal, authorization shall be made by director plus CS if CS is there Two directors if no CS. Okay? Two directors if no CS is there. Right? Okay. See, of course, company, if I'm talking about the features, if I'm talking about the advantages, it also has disadvantages. Right. There are a lot of compliances that you need to do in a company when we're talking about Companies Act. There are also taxation liabilities when we're talking about income tax and um, the winding up procedure is huge when you want to shut down the business. So there is a different procedure that you need to follow. Right. So there are some advantages as well as there are some disadvantages. Amidst that, we have another concept called as corporate wheel. Corporate wheel. See, whenever we say that a company is incorporated, a company is registered. Now, the company is different and the members are different. So, whatever company is doing, only company is responsible for that. Right? That means company has a corporate personality which is distinct from its members, as we read in the concept of separate legal entity. Now, carrying the same concept forward, this, my dear, is known as wheel of incorporation, which actually gives the benefit to the members, that members or the directors or the promoters, they're different from the company, and company being a separate legal entity, an incorporated association is responsible solely for its acts. But when we talk about certain things like fraud, a fraud cannot be done by an artificial person who doesn't have eyes, who doesn't have ears, who cannot speak. A company. A company cannot go ahead and do fraud. Okay, I'm going to do this today. No. A company cannot take advantage of the loopholes of taxation, or a company cannot go ahead and deceive its creditors or evade some taxes. No. It is the brilliant yet corrupted mind of the persons in the company who take advantage of this form of business organization, and through this company they are doing this. So at times this wheel of incorporation, which is actually hiding, we are only concerned about company. We don't need to look behind the real persons who have formed the company or who are running the company. Why? Because company is responsible for its acts. Although it is run by the people, but then when they are running in good faith, if any mistake happens, if any default happens, if anything happens, they are going to be responsible. But at times, what happens is we need to look behind the real persons who are managing the company. That means we are disregarding this corporate personality, we're disregarding this corporate entity, we are actually lifting the curtain, we are lifting this corporate wheel, we are actually removing this legal facade and looking behind the real persons. So law is ignoring that company and the other persons are different. Law is actually trying to look, okay, who did this? Because that person has to be adequately punished for doing this. Fine. So, not always it is the company who is responsible. Sometimes the court identifies that no, this cannot be done by an artificial person. This is a situation which has been done by some humans, it has been done by some people, or it has been done by some other company, or it has been done just to take advantage of this concept of separate legal entity. This has been done, and now we are going to merge these two persons. We are not going to consider them separate. We are going to remove or disregard this corporate entity, and we are actually look behind that, who is the person responsible. Throughout Companies Act, we will find a lot of statutory cases. I mean, like example, if I am running the company and I want to raise funds from public. So I will show them an offer document, I will show them a prospectus, and in that prospectus, I have written a lot of things that, okay, if you give money, this will happen, your money will be this, we will invest it here, we'll do this, we'll do that. So all the information I have given, this information is incorrect. Now, the company cannot write this incorrect information. I have done this. It is my brilliant mind, right? My corrupt mind, my fraudulent mind, my intention to deceive the people around, right? So I am the one who should be adequately punished, right? So of course the funds of the people will be returned by the company, but I should also be punished, so that I don't take advantage of such a type of organization that, okay, whatever happens, the company will only be punished, I can do anything and everything that I want to, whatever fraud I'm doing in the company, it's fine. No, no, no. So in such a case, if there is a misstatement in prospectus, the act itself says that no, company will not be liable. The persons who have authorized the prospectus, they will be liable. So at a lot of places under Companies Act, the people who are doing this are made responsible, and they have been adequately punished, they have been penalized, they have been imprisoned for various things that they do in a company, because it is ultimately human error which is leading to that, right? It could be other also. Now, there are a lot of judgments also where there is no specific law regarding this, but the courts have analyzed the case, and they feel that in this situation the corporate wheel must be lifted, and we must merge these two entities and say as same, and penalize that person who is responsible for doing so. Okay, so we have to read certain judicial cases regarding the same. What are the judicial cases that, ma'am, we have to read? Just a second. The very first one is protection of revenue. Protection of revenue, ma'am, what do we need to learn in these case laws? Do we need to learn the case law, or we need to learn that in which situation the courts in past have lifted the corporate wheel? That means we are talking about the judicial decisions in which corporate wheel in the past have been lifted. So, what exactly do we need to learn in this particular topic? Well, in this particular topic, I wouldn't say that all the case laws are important. At the end of the chapter, I'll be telling you certain case laws that you need to remember for this particular chapter. As of now, you just try to remember that in which situations courts have in past lifted the corporate wheel. So we are reading some judicial cases, some judicial interpretations that, okay, if this particular case comes into picture, we will look behind the real persons and the corporate wheel will be lifted. Okay. Now, the very first one, that if the matters concern the law of taxes, duties, stamps, particularly where the question of controlling interest is in the issue, what do we mean by that, ma'am? See, if I briefly take you through this particular case law, although you're not supposed to know that, but then whenever company is trying to evade taxes, or it is a matter of taxation, duty, stamps, the company will not be liable. Okay, the corporate personality will be disregarded and will look behind the real persons. The second one is determining enemy character of the company. Daimler Company Limited versus Continental Tire and Rubber Company Limited. See, this is basically in the case of war. If India is at war with some other country, during that time of war, the residents over here cannot contract with other country India is at war with, right? Now, supposedly there is a company in India only, incorporated in India, but it is being managed and run by all the residents of that company. So ultimately, somehow this company also becomes a foreign company. Although company is different, the members are different, right? But then this company somehow becomes that company only. So to determine when you're trading with enemy, When the test of control is adopted, that okay, the control of this company belongs to whom. So when you want to test that particular thing to identify whether this country, whether this company which is in India only is our enemy or not, we should contract with that or not. So in such a situation, the corporate wheel is lifted, and now if we look behind the real persons, we'll find out, oh ho, this is our enemy only, and we cannot enter into contract with it. Fine. So when we want to determine the enemy character, or in relation to trading with enemy, you can say. The next is where the companies form other companies as their subsidiaries to act as agent. What do we mean by that, ma'am? See, if you make someone your agent, merely your agent, the other person does not have an identity of its own. If I am the principal and the other person is doing everything as I instruct them to do, right? They are acting on my behalf. Then, if we share a relationship like principal and agent, how the other company is different, right? So, if the company has been formed to act as an agent only, I have formed the company, okay, on my behalf, you do this, on my behalf, you do this, right? So, in that situation, the other person loses its identity and they are actually the same. The next one, company avoiding legal obligations or welfare legislations. Actually, there are two different points also, but they have been merged here into one also. Doesn't matter. Welfare legislation is what? Welfare legislation, like bonus, paying off bonus. Paying off bonus means what, ma'am? Supposedly, a company has a profit of 10,000 crores. Okay. Now, the company thinks, oh my God, if I have so much of profit, I will have to pay so much amount of money to my workers. So, what do I do is, I will divest, or I will reroute some of my income to another company. I'll form another company and I'll reroute the income to another company. I'll transfer some investments to another company. Now I'll have to pay lesser bonus. So this, you have formed this another company just to avoid a welfare legislation. So in this case, both these incomes will be merged and you will be said that you have to pay adequate bonus only. Likewise, we also have legal obligations in all other cases, whenever you are trying to avoid any legal obligation. So, the court may disregard the legal personality, and they can assume that no other company exists. Okay, fine, you are the one who is responsible. The next one is Connors versus Connors Limited, which is important for you to learn. Now, here, to protect the public policy. So there may be a lot of transactions which are opposed to public policy. So we have morals, we have public policy which have been there. And if a particular company is doing such thing which is opposed to public policy, in that particular situation, the corporate personality will be lifted. Then comes your company formed for fraud or improper conduct. Now, this is the point that I already told you in the beginning, that most of the cases when corporate wheel is lifted, it's because the fraud cannot be done by the company, right? So if a company is being incorporated, that okay, fine, we will incorporate a company, we will take some money from the creditors, or maybe we will buy some goods on credit, we will not pay the creditors. That was the sole intention of the company. We will use this money to divest through different sources, and the makers of the company will ultimately take the money which has been derived from the benefits, or they will fill their own pockets, and ultimately they will say that okay, now company doesn't have money, or maybe the company is formed, they take some money, they run away, they close down the company, whatever. So in such cases where fraud is done, or it has been formed for some illegal purpose or for some improper purpose, then in such a situation the corporate wheel will be lifted, and we will look behind the real persons. Okay, then who is it who has to be adequately punished? So no corporate wheel of entity which protects you and the company. No, it is one and the same thing now. Okay, and then we have the last case. The last case If I brief you a little, although when I'm teaching you this at the final level, I don't go into telling you all the case laws in detail, because that's what you read at the previous level. You're not supposed to read it all over again over here. You already know these cases. Well, even if you don't remember, I'll just brief you with a little bit, because otherwise you'll not be able to understand this particular point. See, lifting of corporate will could be done in the case of transfer of shares, which actually was sale of land. What is it happening, ma'am? Supposedly, there's a company which has shut down all its operations. So ultimately, now nobody would want to invest in this particular company, because all the operations have been shut down. The company is not doing anything, but the company still has assets. And if a land belonging to the company has to be sold to some other company, it needs a lot of approvals. So it was prohibited to transfer the land like this, but the shares could be transferred. So transferring the shares actually meant that the sale of land is taking place. So if such thing is happening, well, we will lift the corporate wheel. So corporate wheel will be lifted in this case. Now, because I have told you that you're not supposed to, my dear, learn every case law at this particular level, and I will be telling you which case laws you have to remember. I want you all to please write this. I hope you've started making notes already. The first thing that I made you wrote was about the features of a company, which have to be exactly written the way I have told you. Second thing, um, cases cases of lifting corporate wheel, or you can say judicial cases of lifting corporate wheel. So in the following cases, corporate wheel was lifted by our judiciary. Not exactly in all cases, it's not about the Indian judiciary that we're talking about, but it's okay, right? So you can just say judicial cases. The first one, to protect revenue matters. To protect revenue matters, example, taxes, duties, etc. It happens for individuals also. Clubbing of income is one such proof of provision. When you club the income is clubbed and it is taxable in the hands of one person only. The same thing is happening here also. If you form a company, or if you try to divest your taxes or divest your revenue, if you try to route your revenue through some other entity just to evade taxes, well, then your income will be clubbed, right? So this is what is actually happening. So lifting of corporate wheel gets lifted, and thereafter you both are treated as the same entity. Okay. Second is in case of trading with enemy. Trading with enemy. So when you want to trade with enemy, but you want to test that whether it is your enemy or not, where test of control is adopted. Where test of control is adopted. Then the next one is where you want to form subsidiaries. Forming subsidiaries, but the subsidiaries are not formed. I mean, it is not a company where you are investing a lot of stake, but it is you're forming subsidiary to act as your agent. So here is such a case that subsidiary loses its individuality in favor of its principle. In favor of its principle. Then, whenever the company is trying to avoid legal obligations, or the company is trying to avoid welfare obligations, then we read about protection of public policy. So to protect public policy, anytime people can be punished accordingly by lifting the corporate wheel. In case of quasi criminal cases, or you can say in the cases of fraud, right? So fraud. Then the last one, in case of transfer of shares which actually amounts to sale of land. So it actually amounts to sale of land. Here the transfer of share is taking place, but it actually amounts to sale of land, right? So in that case. So these are all the cases. If at all in examination a question is asked to you about lifting of corporate veil, or it is being asked, see, it may be asked that what do you mean by corporate veil, or write a short note on corporate veil. Then you have to see the marks, obviously. Fortunately, unfortunately, I have to say this because a lot of direct questions are also asked in your examination. So, if at all a question on corporate wheel is asked, you have to remember two things: that you have to write what is wheel of incorporation, you have to write what is lifting of corporate wheel, you have to state that corporate wheel may be lifted under statutory provisions as given in Companies Act, or in a lot of judicial cases in past, the courts have invariably lifted the corporate wheel. In what situations courts have lifted the corporate wheel? These are the list of cases. Okay. Specifically, you don't need to remember the case laws. Some case laws are advisable for you to remember for better scoring, but ultimately, this is the content that you must learn. Okay, so this is the brief or the shortest way possible to enumerate all the cases. So these are the judgments that in these cases courts have in past lifted the corporate wheel, which acts as a guide to all of us for future cases also. Fine. Okay. Now, there is something called as business organization in India. What is business organization, ma'am? See, there are different perspectives of reading this particular topic. The perspective that's been expected by us from our institute is when people form a business, it is mostly for profit motive. There could be non-profit motive also, for which we form Section 8 companies. So mostly I would say people form business for profit motive only. Right. But sometimes people form business to cater to the needs of society. To the needs of society. And this particular sector, my dear, is known as social sector. Now, usually, we are paying taxes, so the government is bound to serve us. The government is bound to provide us the facilities that we deserve, right? That the society needs. Facilities like maybe infrastructure, facilities like maybe postal, facilities like railways. So here the government intention is not to make profits. Railways, I hope you know that it runs into losses, right? Despite taking prices from us, despite that we are booking our tickets, it's not something that it is free. I am not saying that government is doing some charity. No, government is also doing a business only, but that business is not meant to earn profit, right? It is for catering the needs of the society. So you have your set of expenses, you have your set of revenue also. Sometimes maybe some surplus is generated, sometimes maybe some deficit is generated, but the intention is not to make profit, the intention is to serve to the needs of society, right? So social sector usually may generate profit, it may also not generate profit. This may also be the case that there is no profit in this particular social sector. Right, fine, ma'am. When we talk about government, or when we are talking about this social sector, when we are talking about the social sector, let me take you through. Okay, I've written this over here also. Here we come. I don't think I need to rewrite this. Where we come to social sector, it may be a public sector, it may be a joint sector. Fine. I'm not talking about a public company. Mark my words, listen to me very carefully. We are still not talking about companies. Company is a form of business organization, right? Company is a form of business organization, just like we have proprietorship, just like we have partnership, and like things. This is a separate angle that we are discussing over here, that on the basis of government ownership, that government owns this particular venture, government owns this particular thing. Why government will own? Because government is not here to do business. Government is here to render or to the needs or contribute to the needs of society, right? So public sector, where mostly the holding is with government only, right? So it's a public sector. Joint sector, where private sectors and government come together and they work. So here we have government departments, we have statutory corporations, we also have government companies. This comes under Companies Act 2013. Fine. So under section 2 clause 45, we have a concept called as government company, which we'll be reading later, where government has 51% or more shareholding in a particular company, whether it's government company, state company, whether it's government, central government or state government, or a combination of both. So that is called a government company. We also have statutory corporations like RBI, like SBI, like LIC. These are also government owned enterprises, but they're not formed as a company. We have an RBI Act. Under that, RBI is incorporated. We have LIC Act, under which LIC is incorporated. These are known as statutory corporations. Fine. Or these are also known as statutory companies. They are not actually company which is registered under Companies Act. RBI is not a company which is formed under Companies Act. No. It is formed under an Act of Parliament. What is Act of Parliament? RBI Act. Under RBI Act, there was a power to form an organization. And there under RBI is formed. It is a body corporate. It is not a company. Body corporate, why? Because it has features of body corporate. Features of body corporate means, ma'am, RBI, it will continue to be there. Whether RBI, some director comes, they go, or maybe some employees come, they may go, RBI will be intact. Right? So it has perpetual succession, just like company has. All the body corporates will have perpetual succession. Company is a body corporate. All the body corporates are not companies. These are the basics, my dear. Just a quick recall of the basics that you already know and you must know. Fine. So these are also owned by government. Then we also have government departments like railways, postal departments, etc. So here government has a good stake. Here joint sector, where government also invests and the private sector is also investing. Fine. So this is known as joint sector. So in examination, there may be a question which is asked to you, like on the basis of government ownership, what are the two sectors? So you have to specify that we have a public sector, we have a joint sector. In public sector, you can say we have government department, we have statutory corporations, we have government companies. In joint sector, we have entities where government invests between 26 to 50%. If it's more than that, then obviously it's a public sector, right? Clear? Okay. Now, we have still not yet discussed about Section 1 of Companies Act. Right, that Companies Act is applicable on what? No problem. I'll tell you that later. That's not an issue. Now, classification of companies. How companies have been classified. First thing, on the basis of incorporation, not at all important. But here I will take you through the difference also between body corporate and a company. First, we have a registered company. What is registered company? Company which is defined in section 2 clause 20 of the act. Which means company which is incorporated under this act, a previous company law. That means Reliance Industries Limited, incorporated under previous company law, is a company, is a registered company. You call it a registered company, you call it just a company. It is this only, which is falling under Companies Act. Then comes your statutory company. What is statutory company? Or sometimes we also call them as statutory corporations also. Fine, although they are different, but we may call them. What is it? It is different. It is a company which is constituted by special act of parliament or state legislature. As I was explaining you that we have RBI. RBI is not a company which is registered under Companies Act. It is formed under special act of parliament. So there is an act of parliament, just like we have Companies Act which is passed by parliament, we also have RBI Act which is passed by parliament. Under Companies Act you have a company which is incorporated. Under RBI Act you have an entity or you have a corporation which is established, which is RBI. RBI is a body corporate. It is not a company because it is not registered under Companies Act, but under a special act of parliament. So it is a body corporate. It will have some features of a body corporate. A company is also a body corporate, but a company is a company also. But this is only a body corporate. It is not a company. Get my point? So we have State Bank of India, we have LIC, we have IDFC, UTI, state financial corporations. Of course, they are mostly concerned with public utilities. Okay. Now, moving to the next part. Moving to the next part. On the basis of liability, this is the biggest advantage that a company has, that in a company limited by shares, if it is a company may be limited by shares, a company may be limited by guarantee, or it may be also an unlimited company. So if it is limited by shares, the liability of the members of the company will be limited to the amount unpaid on shares held by them. What do you mean by that, ma'am? Supposedly there is a company, this company has issued shares of rupees 10, on which 5 has been paid up. 5 has been paid up. That means the members were asked to pay only rupees 5 till now, maybe application money. So 5 is pending. The company can anytime call this balance 5 money, and I am liable to pay this 5 money. The company cannot ask me to pay 6 rupee. The company is not in a very good financial position. You are the members. You should support the company, and you're liable to pay 10 rupees, 6 rupees, 7 rupee, 8 rupee. No. As member, I am only liable to pay a balance of 5 rupee. That means my liability is going to be limited. It's not going to be unlimited. It's going to be limited to the amount, if any, unpaid on shares held by me. If I have fully paid the amount, that means there is no unpaid amount. So I don't have any liability towards the company now. If I say on which 10 rupees has been paid up, so that I promised the company that I'm taking one share of rupees 10 and I have paid all that 10 rupees to the company. So I'm not liable for anything else. Right? So now I don't have any liability towards the company. Just like that, if it is a guarantee company, the guarantee company may have share capital, guarantee company may not have share capital. Okay. So if there is a guarantee company which has share capital, it will be clubbed like that. If a company doesn't have share capital, it will be only guarantee company. Guarantee company means I have undertaken a guarantee that I will be paying an amount of 1 lakh to you. Okay. So now when the company winds up, when the company is having shortfall to the assets of the company, I am going to contribute that much amount to the company. Fine. Only 1 lakh. My liability is limited to that amount of 1 lakh. And then there are unlimited companies wherein it is as good as proprietorship. Fine. So the maximum liability is my entire property that I have. Okay. Why will anyone form an unlimited company? Because if it has to be, the biggest advantage of forming a company is that you get the feature of limited liability. If you're not getting the feature of limited liability, why form a company? Then get away or be free at least from these compliances that companies have to undertake. Fine. Okay. Now, after we have done this, I think I'll also tell you about this. The meaning of company, I have already told you, right? The basics of company, 470 sections, 7 schedules, 29 chapters, a lot of rules. Received the assent of President on 29th August, was notified on 30th August 2013. If I talk about administration, slowly and gradually, I'll be telling you this because we have a lot of things. The first thing that you know that it is administered by CG through Ministry of Corporate Affairs. Now, in that, you have ROC, Registrar of Companies. You have some official liquidator. You have a public trustee. You have Director of Inspection. You have NCLT. You have NCLAT. The most important thing that you need to remember out of these is ROC and NCLT. ROC, who actually undertakes the entire work. Okay, a new company is being formed, will give the data to ROC. ROC will incorporate, or ROC will maintain all the records. ROC will give you the certificate of incorporation. Whenever any change is made, anything is done, you inform ROC. So every time we have to inform ROC, and ROC is responsible for the incorporation of company and also for administration of these companies. Then we have NCLT, which is the judiciary authority. Okay, apart from that, all these things I'll keep on telling you slowly and gradually. When I talk about extent and applicability of Companies Act extends to whole of India. Fine, ma'am. Applicability on the different types of companies. Companies Act apply to all the companies which are registered under this act or previous company law. It also applies to some company which is governed by special act for the time being in force. And it also applies to some body corporates which are not companies, but they have been notified by CG in this behalf. So Companies Act also applies to certain body corporates. Fine. Okay, ma'am. Now it also applies to 3 special types of companies: insurance, banking, and electricity. Insurance, banking, and electricity. So we have a banking company. Okay. Any company. The banking companies have to carry a name bank in their name just to ensure and just to help people to identify, okay, fine, it's a financial institution. Right. So every banking company will have a bank name, Axis Bank Limited. Right. So you have that bank name. Now there is a company which is a banking company formed under Companies Act, obtains license from RBI to do banking business, to carry out banking objectives, right? So it has got a license from RBI, right? It is also governed by some provisions of RBI. It also has a specific act called as Banking Regulation Act which regulates banks. Now we have 2 places to take instruction from. If I have formed a banking company, will I listen to Companies Act because I'm formed as a company under Companies Act? Or will I listen to Banking Regulation Act because I've got a license to operate as a bank? And if I operate as a bank, I have to follow this Banking Regulation Act which regulates all the banks. So which will I listen to? Well, you will listen to both. Ma'am, how can we listen to both? As long as both are saying the same thing, it's okay. When you get married, if your wife and your mother says the same thing, what is the problem? The problem comes when they are speaking different things. The wife wants you to do this and the mother wants you to do this. Now there will be a problem. Which one to follow? So who will supersede? It will always be the specific act which will supersede. So forget about wife and mother. I cannot answer that. But in terms of Banking Regulation Act and Companies Act, well, the Banking Regulation Act will supersede. So you will follow the specific provisions. So as long as there is no inconsistency between the specific provision and Companies Act, well, you will keep on following Companies Act. But as soon as there comes inconsistency, then you will follow their respective acts. What are the respective acts? For insurance companies, we have Insurance Act and IRDA. For banking companies, we have Banking Regulation Act. For electricity company, we have Electricity Act. Okay? Fine, ma'am. Okay, see you in the next class. Thank you.